jury being able to view the defendant's vehicle. The place has been determined, how it's going to be set up, and where the jurors will come from, where the parties will be. It's still being discussed. I've asked counsel for the state and counsel for the defense to first discuss what they would like. And if it's acceptable to me, then I'm more than happy to follow their agreement if I find it acceptable. If not, I'll come up with a placement plan. I don't anticipate a problem there. We've agreed that we will meet at 8 in the morning, and that the tow truck will be there with the vehicle, so that we can all have an agreement as to its sighting and positioning before the truck driver puts it down and in place, to avoid duplicate efforts if there's something that needs to be tweaked or adjusted in the place where it's determined that he wants to set it down. So everyone is to be there at 8 in the morning, and we'll get it properly placed. Mr. Sharon's going to work with the media as to where the media can have their camera. The media has been advised that there are to be no pictures taken of jurors, so I anticipate they'll want to take their pictures. First, the sheriff is going to be involved in where, it's already agreed where the media can be, and the sheriff is going to be involved with Mr. Sharon as to when and what and how the media will have access to be able to get the pictures that you all want. And then the jurors will come, and one of the issues we need to agree on is how long the view will last. And then after that, they'll be brought back into the courthouse and the trial will resume. So right now, the things that are definite, or we'll meet at 8 o'clock for the placement of the vehicle. Detective Brunstead is here, and the car seat can be delivered to him. State and defense want to be present when the car seat is placed in the vehicle, so you all need to agree on a time, and then I'll come. Why can't y'all need to discuss it? Because it seems to me it can be after hours. Yes, sir.
A couple of suggestions for the court. I've mentioned to the court that I was going to bring up two things while we were doing this meeting, and I also told the court we would do that on the record. The first thing is I have an order prepared. It's a release order. It just needs to be filled in. You've seen this before. This is a topic of discussion before that would allow Detective Grimstead to get this car seat. We do expect to recall him to the stand to lay some foundation for some things. What I propose to the court, we have absolutely no objection to the defense being able to access the vehicle. They've always had that right. We don't have any problem with them doing that with Detective Grimstead, but for efficiency's sake, we've made arrangements with the person that's housing the vehicle right now to allow Detective Grimstead to access it and place the seat and get the appropriate measurement. That would allow the defense at any break or during the lunch break, this record yard is only about 5 minutes away, to send a designee to go confirm with Detective Grimstead what he's done. He's got his tape measure and all that stuff with him. Alternatively, if there's a 3-person defense team here, if one of them wants to go with Detective Grimstead now, for efficiency's sake, it would allow us not to have any delay in being able to present his testimony this afternoon, and that's part of the reason we asked him to come down last night.
Have you all discussed this with each other?
We didn't have an opportunity to do that because we didn't want to do that off the record.
That's what I'm wanting y'all to do first, is talk to one another.
Then let's do that now because
Please do so. Well, we're gonna take a morning break. Well, we can do it at lunch. Okay, so do it at lunch, because we have a timeline that we have to meet. So do it at lunch. That solves that. What's the other concern?
That's all for right now.
Okay. All right, let me, have you showed them the order that you're proposing I sign?
As to form.
You have no objection as to form? Bring it up and I'll sign it.
We had previously objected to the entire procedure.
I know. And you're not waiving that at all.
Specifically, having this reinstalled for purposes of review. We objected to that, continue to object.
All right. Now, when is it you anticipate putting Detective Grimstead back on the witness stand?
Right after lunch.
Okay. This is what makes sense to me. I think he ought to take the car seat. He ought to go down there with his measurements. He ought to put it in the car. You all can go at lunch with your measurements and see where you agree or disagree. Then this afternoon, wherever the disagreements may be, we can discuss that, and I can say, I mean, it may be that you're fine with it, it may be that you're not fine with it. You can tell me after lunch, and then I could say what needs to be done about solving the problem. Does that cause a problem for the state?
That's my recommendation to the court. I think that's the most efficient way of doing this.
What says the defense?
We'll get with Mr. Evans at lunch and discuss what, if anything, that we'll do at that point.
Okay, well, I'm going to go ahead and direct that Detective Grimstead can take the car seat and install it.
Thank you, Your Honor. Judge, the only other thing before Grimstead leaves, we had a discussion yesterday, and I told the court this morning, we would put this on the record as well, about whether we would actually be tendering the vehicle, because there's some question about whether it's an item view versus a scene view, and it could qualify, quite frankly, as either one of those. So what we intend on doing is tendering the motor vehicle. The way we're going to do that is I'm going to direct Detective Grimstead to leave this on the dashboard as a piece of paper. It says Defendant's Hyundai Tucson, and it's got a State's Exhibit sticker 650, so that we can actually tender the vehicle into evidence. Technically, the vehicle's not going to go to the clerk's office. Instead, we're going to ask that this piece of paper be substituted for the purpose of the record, and then Cobb will take custody of the vehicle after the trial of the case and retain it for posterity.
Okay. Well, whether to put in evidence or not is certainly your decision. Are you making a tender at this time?
No, I'll do that with Detective Grimstead.
This afternoon?
Yes, ma'am.
All right, well, you all have been informed, and you'll know how you want to respond when the time comes. That's going to impact my charge, but that's fine, I can fix that. Okay. So, we're going to meet in the morning. We'll all as a group decide if we agree with the placement of the vehicle or not. If there are disagreements, I'll make a decision. We'll put that on the record. Mr. Sharon is going to manage the media according to the sheriff's direction. And topic for the morning is the placement of the parties during the view. Again, I want you all to confer and a morning report where you would like to stand. If there's agreement, good. If there's disagreement, I'll make decisions. We'll come back in the courtroom and make a record. I have a charge going to have to be adjusted given the state's decision to place the vehicle into evidence. I'm going to work on that. I will give you all a copy of what I've come up with as soon as I can, certainly before tomorrow. All right. Any other concerns about the view from this state?
No.
And from the defense?
Not at this time.
All right. Are we ready to go forward?
Yes, sir.
Bring the jury.
Let's all rise for the jury, please. Okay. I know you have.
It's amazing how fast you said that. I'm sure you did.
She's available.
I appreciate you doing that.
Yes, ma'am. Be seated, please.
Ladies and gentlemen, we're ready to resume the trial. Please proceed.
One detective.
As part of the investigation, y'all spoke with and took some evidence from Ross's wife, Leanna Harris.
What are you referring to, sir?
As part of your investigation, you spoke with and took some evidence from Leanna Harris, Ross's wife.
I'm asking, are you talking about the search warrant at the residence? Are you talking about when she was at headquarters?
Well, let's do this.
Okay.
As part of your investigation, did you ever have any conversations with Leanna Harris, you or your detectives?
Yes.
As part of your investigation, did you or your detectives seize any evidence belonging to Leanna Harris?
Yes.
All right. Is she still a suspect?
No.
All right. When did you rule her out as a suspect?
Objection relevance.
No whatever objection.
There's no date that we decided. No evidence has come forward to bring us up to the level of probable cause that you need to get a warrant to arrest Leanna Harris. We've never reached that point. So.
Okay. So you don't have a date certain or a time certain when she was ruled out as a suspect?
No.
Okay. Was that recently?
No.
Was it recently?
Like how recent? Like within the last 2 months?
Mm-hmm.
Or the last week?
Mhm.
What are you asking, sir?
I'm asking when you ruled her out as a suspect.
Objection asked and answered. He said he didn't know, Judge.
Ms. Fuller?
Leanna Harris has been a suspect in this case all the way through. The case is at the final conclusion point and no evidence. So, there's 2 ways to look at her as a suspect. Is she being actively investigated? No, she is not. Did any evidence rise to the point where we had probable cause to take an arrest warrant for Leanna Harris? No, we did not. So at this time, she is a suspect? No, I cannot say that. She's still listed as one on the report, but she is not part of an active investigation.
All right. Was it your theory then that she was aiding her husband in his quest to live some wild, child-free, divorced life? Was that your theory? Why she
At
was
the
a
beginning,
suspect?
at the beginning of the investigation, Leanna made similar comments that her husband did. She made comments about how she, her fear was of her son dying in a car.
I hate to object to this line of questioning, but now we're going into hearsay at this point too. Thank you.
So, due to,
That's been sustained. I didn't ask you what she said.
oh, I'm
So
sorry.
when the judge says sustained, that means you can't keep talking. Okay?
Okay. I'm sorry.
seized her computer, her MacBook?
We did.
Right. And you didn't find any evidence on that MacBook inculpating her in any way, did you?
As I answered before, we did not find any evidence to rise to the part of the probable cause to arrest Leanna Harris.
Okay. Well, the way you're talking, it sounds like you think she's still a suspect. Is she?
Objection, argumentative.
He has him on cross. You can answer.
Thank you, Judge. That's my answer.
Okay. In fact, what you found on one of her devices was about 30,000 images of family pictures, mostly of Cooper Harris.
We did.
And you didn't let her have that back for her son's funeral, did you?
At the time, it was still an active investigation, a very active investigation. The photographs were a piece of evidence. It was discussed thoroughly, and at the end, the decision was made not to release the photographs due to it being a piece of evidence.
So that's no. You didn't give her back her photographs to have when she buried her son. All right?
That's correct.
All right, so we've heard some evidence that Leanna Harris went to the treehouse looking for her husband. And we know that she spoke with Wesley Houston there, and you spoke with him.
I did.
Okay. And she was also, she spoke to some of your investigators there, Detectives and Stockinger at the treehouse?
That's correct.
Okay. That was recorded, correct?
I believe so.
Well, you've had a chance to listen to that interview of Leanna Harris done by Stockinger and Racy, haven't you?
I'd have to refresh my memory of the notes. I have not listened to it recently.
Okay. Well, if an interview was done by your detectives at the scene immediately after she discovered the death of her son, and it became part of the case file, are you saying you're not sure if you listened to that interview?
No. What I'm saying is right now, I can't tell you that there's recording. I'm sure I've listened. If there's recording, I've listened to it. If it went into my case file, I've listened to it. But sitting here right now, I can't tell you right now.
What you learned about the initial stages of investigation as far as Leanna Harris was concerned, she didn't show much emotion, did she?
Yes.
Yes, meaning she did not show much emotion?
Yes.
It's been reported there were no tears.
Correct.
And you testified about this in July of 2014, that she didn't show any emotion and she didn't ask to see her son, right?
Correct.
And then later on, you had an opportunity to speak with Leanna Harris at police headquarters.
That's correct.
And you searched her belongings.
I did.
You went through her bag. You went through her wallet.
That's correct.
She wasn't in custody.
She was detained.
She was detained.
And she was not allowed to leave. She was being questioned results or concerning her, the son's.
Do you have any report there in your little binder that says Leanna Harris was detained?
She was brought to headquarters, and she said, when you listen to the interview, we speak about you hear of your own free will. She says yes, but if pushed, I would have to say, she wasn't free to leave.
Okay. In other words, you don't have any report that says anything about the fact that she was detained?
No.
And you've never testified before about the fact that she was detained at headquarters?
No.
In fact, isn't it true that what happened was the detectives were concerned about Leanna's ability to drive herself because of the news that they had just had to deliver to her about the death of her son.
That was part of it.
And then once she got there, apparently, we're now hearing you made the decision that she was going to be detained.
When she got there, if she would have decided she tried to leave at that time, I would have had to say no.
So after you went through her stuff, you had an opportunity to observe her demeanor.
That's correct.
And your report, you indicated that her demeanor was calm and collected.
I do.
And there's no report that you made that she was crying or had tears or showed any emotion, right?
That's correct.
Is that why she was a suspect?
In the statements that she made.
I'm asking about her demeanor and emotion.
Yes.
She wasn't reacting the way you thought that she should be reacting. Isn't that true?
That's part of it.
And we've all seen the recording where you allowed them to speak to one another,
That's correct.
right?
That is correct.
And if he was detained and she was detained, then obviously you thought something suspicious was going on, so you wanted to put them together and observe them secretly.
That is not. They're in a room with visible video cameras. They've both just been interviewed in regards to an investigation. They knew they were being recorded, or should have known they were being recorded. And they both asked to see each other.
They should have known.
They should have or did know.
It's not like they had a lot of going on then, stress-wise, was it?
I don't understand your question.
We see in that video that Leanna Harris is she's calm and she's reassuring to her husband. Isn't that true?
That's true.
And we don't see her falling out, having a fit, crying. We don't see any of that, do we?
No, we don't.
And that's why you consider her a suspect, because you don't think she reacted the way you think she should have.
And that is a very small part. It's the whole picture. You have to know all the pieces to know why she was considered a suspect.
We do have her see on that recording almost the entirety of the time they're in there. We see Ross crying and carrying on and being very emotional.
Yes, at that time when Leanna and him were together, they were both very, well, he was very emotional.
He was way on one side of the emotional spectrum, and she was on the other. Is that fair to say?
And that would be fair to say.
And we also see him continuously wiping his eyes and wiping his nose.
True.
Okay. That's what happens when you cry, right?
Agreed.
Okay. And in fact, at one point in time, he's asking her for a tissue, and she says, "All I have is a sanitary napkin."
Correct.
Okay. That's something when you cry, you need tissues, right?
That's
Or
correct.
you wipe it on your shirt.
That's correct.
Fact of the matter is, you were dead wrong about Leanna Harris. She's in no way involved in any sort of conspiracy with her husband, is she?
And that's been answered. She is not a suspect involved in an active investigation at this time.
true, you're looking for a conspiracy, and you're looking for nefarious motive. So you're seeing what you want to see.
Judge, now I'm going to object if that is argumentative.
It is argumentative.
Okay. Thank you, Detective.
Thank you, sir.
Detective, just touching back on that, I guess the last thing we heard, I'm kind of a train of thought guy, so
Yes, sir.
as we were talking about the interview, or not the interview, the discussion between Leanna and the defendant in the interview room, you saw him wiping his nose, asking for tissue, things like that, saw real tears. See any of that before he was informed?
He's leading, objection.
That's not suggestive, Judge.
I didn't hear the whole question, so it's hard to
Okay.
say. So if you will state your question.
I will, thank you. Was that before or after he was told he was going to be arrested?
That was after.
Was that before or after he was put back in the cell and as he complained about an uncomfortable cot and a metal toilet?
After.
And the majority of the time he's in that room, is he complaining about himself?
No. Well, yes, I'm sorry. He is.
Okay. And when you talk about him being emotional and things like that, do you notice times in there where he actually is more interested, or is interested, sorry, that's argumentative, interested in what other people are saying about it?
That's correct.
And actually sees a phone buzz and starts asking, calms down, oh, who's texting?
That's correct.
You talked a little bit about whether you seized any computers. When you initially seized these computers, did you know who each computer belonged to? If it was used by defendant, by
They're
Leanna
electronics.
Harris?
No, they were electronics found at the residence.
Okay. Now, did you in fact in some of the computers find evidence that, going back years, that they had had problems and there had been issues of infidelity that she somewhat knew about?
Yes.
The defense asked you about whether you turned over pictures for the funeral and things like that. Was that a big discussion both with the DA's office about whether we could do that, given the investigation, or whether
I'm
the
going to object. I guess that would be hearsay about some discussion that was had in the DA's office.
judge you already asked about discussions at the office and who he consulted about whether to turn over these pictures or not?
You can go into it.
Thank you. Were there discussions about the legalities of it and whether it would taint evidence if you're still investigating and examining a computer and then trying to turn it back over?
That's correct.
Okay. And did you eventually, did y'all actually try to extract all the photos you could get off of her computer and turn them over to her attorney?
We did.
And I think you answered this, Detective. Mr. Kilgore tried to portray it as you thought she was a suspect because of her demeanor. Were there other reasons and things like that? Was demeanor just a part of it?
It was multiple reasons.
Okay. And the same thing with the defendant on scene. Was that just one of the things that initially y'all took into consideration as far as when to investigate and how to investigate further his behavior?
It was just a piece. It was a piece of the investigation.
Okay. Just to start off with, just a few things to clear up. Mr. Kilgore asked you about messaging with Elizabeth Smith, the defendant messaging with Elizabeth Smith on the morning of. You remember that?
Yes, sir.
Oh, great. Now, this was a woman he had actually met up with twice, correct?
Correct.
But they had talked for months and months, numerous times, about sexual conversations.
Correct.
So did they meet up every time they had a sexual conversation?
No.
Okay, and just to be clear, what was the statement? I think Mr. Kilgore portrayed it as he asked her to meet him to have sexual acts, correct?
Correct.
What is the actual statement that he says to her that morning? We've heard enough of.
You can
Okay, you can say that.
you can come suck me today.
Did they ever discuss meeting up, where they're going to meet up, anything like that?
No.
Okay. And did you see the time on that, by chance?
I think it was 7.
Let me just show you so we're accurate.
Yes. 7:25:56 a.m.
Okay, so that's 2 hours before he locked Cooper in the car, correct?
That's correct.
numerous occasions the defendant would message people and talk sexually without actually meeting up with them.
Correct.
Okay, let's clear up some of these issues about the phone calls on the scene. Defense counsel asked you some questions about, could your officers have hit butt dialed or redialed or something?
Yes.
How many calls were reflected on all of the records to Little Apron or to Home Depot, just generally, at 4:25 on June 18th?
2 calls.
Okay. When you spoke with the defendant, how many times did he say he called Little Apron Academy?
2 times.
And the Little Apron Academy records, where it shows the extension dial to go into it, was that dialed on those occasions on June 18th?
It was dialed both times.
So this was not just some general call to a general number.
It was not.
So defense asked you if it could be consistent with butt dialing and things like that. Could it also be consistent with he made a call, it got connected, and then he got detained while the phone was still going?
That's correct.
All right. One other point of clarification. I think you may have covered it, but the GoPro videos. The difference. One of the differences between the times that you ran initially back 2 years before the GoPro videos, in addition to different traffic patterns, school, things like that. Did you actually also start the video much earlier in the GoPro videos, as far as being in the parking lot and driving through the parking lot, as opposed to just leaving Chick-fil-A back in 2014 with those times?
That's correct.
There was a question about the radio, I think. Let's see. Okay. In your interview with the defendant, you asked him about whether he was listening to the radio or anything like that, and what he was doing in the car, correct?
Correct.
Okay, I'm going to ask you, if you look at the transcript, would that refresh your recollection about what exactly he said regarding what he was doing? When you asked him, when you left there, were you on the phone? What did he say?
Nope.
Were you talking to anybody? What did he say?
Nope.
What were you listening to on the radio?
Probably 104.7. I mean, I just know I wasn't doing anything. I just left.
Now, did he even say he definitively was listening to the radio?
No.
Did he say he was doing anything at that moment whatsoever distracting him?
Yep.
Okay, going back to the passcode again. When he gave you that passcode, from that video, didn't you actually tell him, we're charging your phone and we know you have a passcode?
Yes.
And with the Whisper app, did it actually, even though it was hidden, did it also have a different passcode?
Judge, I'm going to object. He's leading every question.
Did it have a passcode? How was that leading? I would say, it did have a passcode, didn't it? That would be leading.
He's testifying and then simply having the witness agree or disagree with what Mr. Bourne is saying. That's what leading is. And so I haven't been objecting every time, Judge, but I'm going to start objecting.
Carefully phrase your question so as not to be leading, but I didn't find that last question to be leading.
Thank you. The Whisper app, after it was, found that it was hidden on the phone, did it have a separate passcode as well?
Yes.
Okay, you pulled the defendant's Tuscaloosa PD records. I know he said that he'd been there 5 years, I guess. How long had he worked as a dispatcher per the records that you received?
3 years.
Defense counsel asked you some questions about when you, at the scene after he got handcuffed and in the interview, were these, I think it was said, it was a good opportunity to act up. Would it also have been a good way to convince you people, or you detectives, officers, of his story?
Yes.
Objection, speculation.
It's the converse of the exact question the defense asked.
Well, he didn't object to my question.
Regardless, you can ask.
Thank you. Would it also been a good opportunity to convince you guys of his story or talk his way out of it?
Yes.
Okay. And when the handcuffs came out, did he immediately, his demeanor change and try to talk his way out of it?
Yes.
Okay, we talked a lot about smell and things like that. We talked about, excuse me, crime scene tech Shumpert, Martin Jackson, James Hawkins, first responders, things like that. Other than Captain Farrell at the scene, did anybody put their head in the car?
That's what I'm aware of.
Did any of those guys ever get in the car as far as you're
Not
aware?
that I'm aware of.
The people who actually got in the car that evening would have been you, Captain Farrell, and Grimstead, correct?
Correct.
And even though none of these other people got in the car, the child's out in the elements. Make sure we're clear. Did you actually get down and say that you smelled anything coming from the child? Did you get close to the child at all?
No.
Okay. But these other people, James Hawkins, Bradley Shumpert, Martin Jackson, they also were down with the child at some point and noted that they smelled something.
Correct.
Now, when the defendant, given his timeline, he got in the car that afternoon after the car had been out there all day. According to him, was there any emergency situation for him to worry about when he first got in that car until he got to Acres Mill and had discovered his son?
No.
Any of those witnesses that were at the scene, first responders, any of those, did any of those people open up the defendant's car door at lunch after the child had been strapped into the car for 3 hours?
No.
Did any of them open up the car door at 4:15 that day after the child had been strapped into that car for 7 hours almost?
No.
Did any of them experience opening that hot car, sit down, and drive off within 3 seconds without the windows rolled down?
No.
Did any of those others drive for minutes with this deceased child sitting inches from him?
No.
There were several questions about Detective Murphy and things like that. All the interviews he did, were those all recorded and turned over to both parties in this case?
Correct.
Okay. And a number of those people who he interviewed, were you actually present for the interviews as well?
Yes.
And these people that he interviewed, did they actually come in here and give live testimony, a lot of them?
Yes.
Going back to lunch, you were asked about Winston Milling and whether he initially, I think he was interviewed a day after the incident, correct?
Correct.
And that he forgot to mention that he went to Home Depot.
Correct.
In fact, he said that when they were dropped off, what did he say about it when they dropped Ross off? Did he even remember where he dropped him off or if it was somewhere different?
He did not remember.
Now, the defendant, was he able to give vivid details of that day, from waking up to strapping the child in to what he said to him throughout the day?
That's correct.
And we saw how he reacted when he was talking about the Publix and things like that.
Objection. That's just a statement, no question.
That was a segue into the next question, Judge. It was a transition. Thank you.